There we go. And we have a fairly good turnout today. So thank you very much, everybody, for participating. If anybody else wants to come in, I'll certainly let them in as we progress. So if we turn to our agenda, so everybody should have their agenda and the minutes that we sent out in the last few days. Roll call, we have some regrets. John is Winterdick, Francois, Lynn, and about half an hour ago, I sadly received a email from Gil, who has resigned. I don't know whether he's resigned from the CCGA in total or just the PRC, but he just said it was time, and Irving has a copy of it as well.
Yeah,
and he just said that it was just time for him to make room for others, I think is the way he put it. He just doesn't think he can dedicate the time and resources to make a contribution to the PRC, and so there we go. So that was I expressed our regrets at that, but it's certainly his decision, and we have to respect that. So that's yes, Howard.
Just Gil has been around as long as longer than I have, and his voice is a constant voice of common sense and decency. Irving, I wondered if will the CCJ send him some kind of more formal letter thanking him for his contribution over the years?
I thought I would drop him a line. I think that should suffice.
Could you make it on behalf of the PRC members? And I mean, I will miss Gil. He again, he's always been a voice of decency. And anyway,
Sure, thanks. Good idea.
Okay, thanks, Irving. Thank you, Howard. Okay, as far as the agenda goes, item 2, I need someone to move the approval of the agenda. Howard, seconded. Matthew, and all in favor? Super, thank you. And likewise, the approval of the minutes from our last meeting, which was October the 11th. So a mover for that approval. Matthew, a seconder. Brendan, right, all in favor? Wonderful, thank you very much. Okay, item 4 on the agenda, news and announcements and what have you. I've included a matter that we touched on last day, plus added some issues I think that are certainly of note to discuss. The first one is, and this came from our last meeting, the Supreme Court ruling on the issue of life without parole. That was the Bissonnette decision and consecutive ineligibility for parole, basically. And Peter indicated that he had an interest in this. So I just wonder whether, Peter, you had any more thoughts about that issue?
I still have a very big interest in it, and I didn't get the brief piece drafted yet, but I have done some additional research on it, and I'll try and get something for the next meeting.
Oh, that's well. All right, so you are going to prepare a brief, and that's great. Thank you very much. Anybody else on that issue? Next, and this is a relatively recent piece. The Supreme Court has ruled that the sex offender registry, the mandatory sex offender registry, is unconstitutional, which is going to generate, I believe the thoughts are it's going to generate some new legislation as a function of that ruling. Anybody have any thoughts on this issue?
I just have a question for the lawyers, and this probably pertains to you, Miles and Howard. With this particular Supreme Court decision, does a sex offender in the community have the standing to petition a superior court to remove them from the registry?
I don't know. I don't think that they, in fact, that there is an escape mechanism, but maybe Howard knows about it. I think once you're on it, it's a lifetime commitment.
Matthew, it's a very good question. I mean, the SEC dealt with 2 issues: the mandatory placement on the registry after a second conviction, I think it is, for sexual assault, plus the mandatory placement on the registry on conviction, and the mandatory placement for life on a second. The SEC struck them both down. They suspended one of the 2, and I'm trying to remember which one it was, and invited people to bring applications, and I think it's the lifetime ban. So I'm sorry, my cold is obviously affecting my head. One of the mandatory provisions was struck down immediately, and I think it's the automatic registration, meaning that the court can register but doesn't have to. The other part that it struck down, again, I think the lifetime, and it could be the opposite. The court suspended the effect of its decision for a period of time, but invited people to make application to a court. So I think you can make application to a court as of the date of the decision, removing you from your lifetime listing. But if in an individual case, you were placed on the registry, henceforth, depending on which one they suspended, your entry won't be automatic, but the judge will have the discretion to do so. In cases in the past, I guess there's no way of telling whether the court did so because it was required to mandatorily, or whether it did so on its own discretion. And Matthew, I just don't know. We have links in the newsletter to all of these things, and what I've been trying to include under what we do is include an article, not the court decision itself, because not all of our members want to read the whole court decision. So if you link on the article, we always try and find a good journalist who's familiar with the law, who writes well about the particular case. But below the article, we include these days a link to the SCC's decision document called Case in Brief. Now, the Case in Brief, you may know, is produced by the Supreme Court of Canada. It cannot be cited in court. It's not an official legal document, but it is their best plain language summary of the decision. And it also includes a link to the full decision. But the Case in Brief, if you could go to the newsletter, read down underneath the article, there should be another little line that says click here for the SCC's Case in Brief. That will take you to a very clear, very plain language summary of the decision as well. So we tried to do that last week, and this week there's been a lot of SCC activity. But Matthew, it's a good question, and my answer is a little bit rambling and muddled, but I'm going to blame my head cold for that.
Thanks, Howard. I don't have a cold, but I have no reason to, no excuse not to have a better answer for you either, Matthew. So I apologize for that.
Just wanted to say, Miles, that the Solicitor General in Alberta put out a fairly heavy-handed rebuttal against what the Supreme Court did. In fact, it was very, very political out here. Yeah, well, the unconstitutionality is suspended for a year. And I think it's the second part, the mandatory life commitment. And I think that the idea is that, in fact, there is going to be responses made and invitations for legislation. So we'll have to we'll keep it on the agenda just as a waiting brief, or just something to watch to see what happens, and anything that happens by way of update, we'll just discuss it as we go forward. That's the best we can do.
The Alberta Minister of Justice has asked the federal government to use the notwithstanding clause to override the decision. And those of you who aren't in Ontario may not be aware, but there's been a tremendous controversy here with the Premier of Ontario invoking the notwithstanding clause to abrogate collective bargaining rights for one of the support staff unions of the teachers, or the Educational Workers Association under CUPE. Just yesterday, Ford, the Premier of Ontario, had to back down because basically he was threatened with a general strike. But Ford has used the notwithstanding clause before. Quebec uses it with some frequency. The Alberta call for it, which I think has been echoed in a few other places with respect to the registry, is worrisome from a lawyer's perspective. I think the destigmatization, if I can put it that way, or the regularization of invocation of these notwithstanding clause means that charter rights are, as one commentator put it last night, not worth the paper they're written on. If federal and provincial legislatures regularly invoke it, the charter has much less value. Now, the federal government has never invoked it, but as I say, I think Quebec is on the high end of the spectrum in terms of invoking, and it's something to watch. Alberta's call to do that with respect to the sex offender registry seems to misunderstand that a court still has the discretion not only to put someone on the registry, but to do it for life. It just is a matter for the judge's discretion. I apologize, Miles, for going on so long, but some of you will remember one of the reasons why it was made mandatory under the Harper government is when the sex offender registry was enacted, and I was at the Department of Justice at the time, although not involved in the file, the courts weren't using it. The courts were not placing many people on the registry. So there was a political backlash, and that was resulted in both provisions being made mandatory, which is entry on the registry and then entry on for life if you've had the subsequent or the second conviction. So we'll have to see how this all ends up. It's an interesting matter, but again, the registry hasn't been invalidated in any way, shape, or form. Just the court has struck down one immediately, not the other one, not immediately, the mandatory nature of the registration.
Thank you. Yep, absolutely correct. All right, guys, moving on. The next issue I put on the agenda was simply just to recite Howard's notice to us last time that he has law students that are funded and looking for issues for them. I don't know, Howard, whether you had found an issue for them at this point or not.
Well, I must admit, my cold seems to have made me in danger of talking way too much, so I apologize for that. But just before we get to my pro bono law students, can I step back? In this past week's newsletter, there was also a reference to the Sharma case, the SEC ruling, where the SEC declined to strike down Harper error limitations on the conditional sentence of imprisonment. And the Sharma case involved an Indigenous individual. It's an incredibly important decision, and it's in the newsletter. So I just wanted to touch on it briefly. In the newsletter, we gave you two articles, one from slightly different perspectives, and then again, the case in brief. But it marks a step back by the Supreme Court of Canada from what some would describe as its activist approach with respect to Bissonnette, the sex offender registry, and other things. It upheld the Harper error provisions, which limited the availability of conditional sentences in cases where the maximum penalty, the offense carried a maximum penalty of 10 years or 14 years and above. The SEC declined to strike it down. It was a 5-4 split, and there have been a lot of those lately, and that worries me because 5-4 splits simply invite someone to challenge it in the near future. It's not unforeseen or unknown for the SEC to strike down or change or overrule one of its previous decisions, but usually it's one of 20 years or more in the past. 5-4 splits means it's not a strong decision, and the Supreme Court Justice, who was their criminal law expert, who retired as of September the 1st, had a hand in this judgment. So the balance is already changed, which will invite some people potentially to challenge. So that's a legal issue. The 5-4 splits are problematic because the law isn't clearly settled comfortably for a period of time. But the Sharma case also says, the majority says some very odd things, I think, about the obligation of the state to advance Gladue principles and to respond to the overrepresentation of Indigenous people in our criminal justice system, right from charging and policing on through to corrections. So anyway, there's some interesting stuff. I really encourage you to take a look at the newsletter. The court has been extremely active in its decisions. This may be a step back. I don't know. It's hard to tell whether it's a trend. 5-4 splits are difficult, but I think this decision, although the logic of the majority may be correct about the conditional sentence, and basically they say the legislature should be dealing with this, Parliament, not courts. Courts should not legislate. It's up to Parliament what restrictions are placed on a sentencing option. While the logic of that is correct, there's statements about the obligation under Section 15 and other parts of the Charter to advance equality or equitable treatment for Indigenous people and for Blacks. Those of you who've seen the Correctional Investigators Report, and I know we'll get to that, it focuses a lot on the overrepresentation of Blacks as well as Indigenous. It's an interesting decision in the sense of I think, letting government off the hook a little bit in terms of an obligation to attempt to redress the imbalance in our system. So anyway, that's just a few thoughts, but have a look at the newsletter. We try and put some of the good stuff in there. And the last couple of weeks, the last year, there's been a lot of SEC activities. So anyway, sorry, Miles.
So Howard, I have a question for you back to the agenda with respect to your law students.
Yeah.
You have funding. Is it for writs? Is it for judicial reviews? What is it for?
We have now for the fourth year in a row taken advantage of a program called the Pro Bono Student Canada program. It's a Canada-wide program. We deal with the University of Ottawa here in town, where you can apply to the program to have an intern assigned to your organization, in our case, the CCJA, as a charitable voluntary sector organization. For the last 3 years or so, I've had 2 students. You have to be a lawyer. So one of the reasons why the CCJA hasn't always taken advantage of this is that you have to have a lawyer ready to supervise them. So you have to be anyway, it's not something everyone can take on. But remember, Mark Edo did some work for us on policing and racism and all sorts of other things. We've had some very good work from our students. Bill C5, which Brendan and I sort of led, our 2 students helped us a great deal on that brief as well. So it's of no cost to CCJA, but we cannot have them do legal work. And what the work they do has to be under the supervision of a lawyer. My one deficit is I don't care errors and omissions liability insurance. So, but the Pro Bono Student Canada group have made an exception for me because I'm sort of a long-standing member, and I have to verify, promise, undertake that they will not do legal work per se. So the work we have them doing are policy research papers in support of the work of the PRC and the CCJA and draft briefs. Where we use those publicly, we do not list them under the names of the students, which bothers me a little bit because I like them to get credit, although they can use the papers in other ways under their names. But I have to undertake to make sure that they are not giving legal advice or representation. And Matthew, the kinds of areas you're talking about, the writs, the judicial review, which would be a wonderful area to get into. I cannot have the Pro Bono Student Canadas do that. And I'm not licensed well, I am licensed, I'm not insured to take on that kind of an activity.
Let me put an idea in your ear, if you don't mind.
Not at all.
Take a look at the model of the Queen's Prison Law Clinic.
Yeah.
Now, they don't do a whole lot of litigation, but they do representation. And if Ottawa was to set up, this is the law school now, if Ottawa was to set up a prison law clinic with a little bit more of a litigious approach, I can sure supply you with a lot of clients who have civil rights issues percolating.
No, Matthew, I know your interest and involvement in this, and you and I both watch. I went to Queens and I was involved in their legal aid clinic, and I know Ellen Manson very well, who championed the prison law clinic and some of the subsequent people who took over. They have to have a licensed lawyer who's insured supervising them, and they can work under that notion. I'm licensed but not insured. I'm sort of inactive but still a member of the LSO, the Law Society of Ontario. Fortunately, the CCLA and the BCLA do a lot of that kind of work. There are organizations. John Howard has become incredibly active in litigation since Catherine Latimer took over as the executive director. And Catherine, of course, is a lawyer, and I assume she maintains some insurance through John Howard. It's not something that the CCJ has ever gotten into because it's a very active adversarial and advocacy role. And although Irving's got his head down and not looking at us, I know he would quickly jump in to wonder whether it's an appropriate thing for the CCJA to take on. Like you, Matthew, I wouldn't mind testing some of those boundaries. And there's no end of correctional issues where judicial review would be a helpful tool. Although there's an interesting thing in Alberta, it's in the newsletter, there's an article about the Superior Court in Alberta having basically developed a procedure and a rule that almost limits habeas corpus applications for prisoners. So have a look at the newsletter. But prerogative writs are a very active and important way to go. But Matthew, I think it's not something I can help my students get into, and I don't think they can get into in the context of their work with the CCJA. There is a prison law clinic at the U of O as well, and one of my students is also involved in that. And I'm trying to link her with Justin Pichet, who you'll know by name and reputation as well. But anyway, to answer Miles' question, and I apologize for hijacking the agenda, and I'm going to blame my head cold. But the two students this year has expressed a strong interest. One in intimate partner violence, and there is a Justice and Human Rights Committee report earlier this year on the potential of creating offensive, coercive, and controlling conduct as a precursor to intimate partner violence, and there's a private member's bill. So one of the students hopefully will be looking at that. The other one's going to be doing some work in the area of the remand population, indigenous overrepresentation, GLADU principles, the extent to which they apply to bail, and other sorts of things. So they're both of my students this year are bright and capable. I'm going to be bringing them to a future PRC meeting. I'll consult with Miles on that. We'll bring them when we've got a clearer idea of what it is they're doing, and hopefully their work can feed into future projects of the PRC. So again, apologies for being long-winded.
No, that's wonderful. Thank you. And thank you, Matthew, for those questions. I was just going to go back very quickly before we move on to Sharma, because I was going to be bringing it onto the agenda before it was preempted kind of thing. So what I was most disappointed in the decision, and you know, because the challenge was both under Section 15 for the discrimination nature of it, but Section 7 of the Charter. So conditional sentences is one of the things I did a fair bit of research and writing on at one point. And so in 2011, 2012, I published an article just after Harper had eviscerated the opportunities for them. So for those of you who don't know, conditional sentences were put into place initially around 1998, just at the tail end of the major reform to the criminal code sentencing provisions. And it was actually worked on by Julian Roberts, who is a very well and esteemed member of the U of O faculty. He's now at Oxford, and he's on the UK Sentencing Commission and what have you. But the whole point of them was, you know, was clearly it is a form of custody, but for, you know, inmates to be actually, you know, in the community, and it almost always involves very strict conditions of house arrest and what have you. But what happened in fairly quickly after its enactment, and this was both by the Liberals and then by Harper, were the various offenses that were available were continuously being restricted. So the movement by Harper in 2011, where he changed the upper limit for the offenses from 14 to 10 to disqualify offenses, pretty much eliminated about half of the offenses that were available to be a conditional sentence. And I always thought that it was relatively unprincipled. There wasn't anything that Harper relied upon for certainly no research they relied upon to restrict the availability of conditional sentences, other than simply his usual, well, I have the mandate of the people, so we don't care what lawyers and professors and those who do research in these fields have to say. It's irrelevant to what we want to do, and that's what he did. So I was disappointed that the Supreme Court, in fact, didn't take a crack at that particular part of the regime of restricting the access. But Howard's quite correct. They did say that maybe perhaps if it's going to be addressed, it has to be addressed by a future Parliament and not by the courts. So anyway, that's my 2 cents on conditional sentences. It's Howard.
Miles, that's excellent. You know, I was at the department at the time, although not involved in that particular thing. But as you point out, the Liberals, the moment the conditional sentence was available and courts started to seize upon it, because there are so few alternatives to imprisonment in our criminal code. And the first time it was used in a sexual assault case, there was a huge outcry. And so there were waves of amendments under the Liberals, and then the Conservatives really shut it down. A Superior Court judge in Ontario wrote an article not long after the Harper Amendment saying you can only get a conditional sentence for a minor property offense now, nothing else. It's not just the maximum penalty offenses. That makes some sense, but also you cannot get a conditional sentence where there's a minimum, a mandatory minimum, which doesn't make sense if you're saying the conditional sentence of imprisonment is akin to a sentence of imprisonment. So the courts, to the extent that they're striking down mandatory minimums, are opening up the conditional sentence. And Bill C-5 has some mild proposals to open it up as well. The real debate here in Sharma, and we've seen it before, is how far courts should go in rewriting the law. And whose responsibility is that? But the conditional sentence of imprisonment still is so restricted in its availability, even after Bill C-5. One has to wonder if we haven't gutted it. A couple of criminologists I know well, Tony Dube among them, have said the only solution is to repeal it entirely, the conditional sentence of imprisonment, and start all over again. That it was inherently limited almost from the start. But the poverty, the words are escaping me today, but the very poor state of the criminal code in terms of alternatives to incarceration lead to or contribute to incarceration being used as a sanction of knee-jerk reaction, not of last resort, but of frequent use. And so anything we can do to encourage alternatives to imprisonment in the criminal code, I think is policy that should be encouraged. It's just the current government seems not much inclined to take on criminal code amendments, but anyway.
That's a great segue back to the correctional investigators' fascinating annual report. Miles?
Yeah, thanks again, Howard, and thank you, Matthew. I mean, that's our next item on the agenda is the fact that the report's been released. So, I mean, Irving may have comments, Matthew, whatever. Anybody want to have a go at what's in the report?
Well, I think Howard has already introduced it, and you've got the link there. I guess the three major points that I recall, one is, of course, the overrepresentation of Black offenders. The second is the overrepresentation of Indigenous offenders. And then the third aspect is his commentary on the use of isolation, segregation, as I guess the lack of progress that he sees, that Ivan sees in terms of the implementation of the SIUs. And you've also got the responses from CSC for each one of those recommendations.
Right, thank you. Matthew, do you want to add to that?
I've been following the correctional investigative report since I've been on the policy review committee in the early 90s. And this, as of course, it's an ombudsman role. They don't have any authority to order anything. And it's always kind of fascinating to me as we pour billions of dollars into a prison system. I think the annual budget for CSC, correct me, Irving, $2.7 billion operating.
I haven't seen the latest budget from CSC, but it must be close to 3, if not over 3 billion.
And then the amount of real estate that they own, correct me, Irving, 52 institutions, at least $3 billion in property. I'd be happy to be corrected on this. And to see
were you planning to buy some property from CSC?
The CSC, Irving, doesn't like me. I don't think they would be selling me anything.
Go on, sorry.
In any event, this is a historic trend. It's been around for decades.
You know, Ivan in his report, Ivan Zinger, points out the number of vacant cells within CSC's real estate holdings, which is interesting. I didn't realize that the population had dropped so much, but it's probably as a result of their major construction program when they doubled up in a whole bunch of different places. And now I guess that's a positive sign if they're actually vacant cells.
True. Anything else, guys, on the?
I should say, though, just to be clear with what Ivan is suggesting is basically try to move some of that money out of the real estate and into the community programming area.
Sure. Yes, Howard.
Irving, I don't know if you want to comment on Ivan's recommendation, which he's been making for a long time, about a new executive position at CSC to deal with Indigenous overrepresentation, and the fact that it has actually just been done. If you take a look at the newsletter, one of the items in the newsletter is an article on that. CSC has finally caved to a longstanding recommendation. Although I must say, of all the recommendations that Ivan and others have made, I'm not sure that's the best recommendation. But Irving, can I get you to chime in on that?
Well, I think you've heard me in the past being rather skeptical about that particular recommendation. I think there was a political need for that to happen. I guess it's going to be happening now. I read what you read in the article from the Globe, I think it was. I would have written that article a bit differently. I think it starts off saying that we're going to reduce the appointment of, I guess it's going to be a deputy commissioner of Indigenous affairs or Indigenous issues, is going to reduce the incarceration rate for Aboriginal offenders. Well, that's not going to happen that quickly, is it? I don't think that fiddling with the executive structure is going to change it. And nor is it, I don't think it's going to improve the problem either. If you have the example of years ago, and we talked about this some PRC meetings ago, post our board, they created a position of deputy commissioner for women. We all remember that. And if you look at the numbers, I don't have them in front of me, but I think a fair guess is that the number of incarcerated women at the federal level has at least doubled since then. So this is not it's not a silver bullet, as we say, by any means. Presumably, it'll give more focus to Aboriginal programming, and Ivan Zinger does point out a number of the issues in that regard, from assessment to programming to release and so forth. If it does that, I guess it's accomplished something, but by itself, it's not going to be the salve that solves all problems.
Andrea, do you have something to say?
I was just gonna say before we moved on, just to highlight as well that just a few days prior to the OCI's annual report coming out, the Structured Intervention Unit Implementation Advisory Panel released their first annual report as well. And for me, really interesting reading that particular report, and then the third investigation in the OCI's report on restricted housing and how those two things meld together to get a more fulsome picture of what's actually happening behind the walls within CSC for their difficult to manage clients, and where trying to figure out where exactly they are being housed. So just wanted to flag that that's another report that was recently put out as well.
All right, thank you. Yes, Howard.
Andrea, can you send that to me? I for some reason I don't have it. I'm always watching for what Howard and Sapers and Tony Dube are doing, but if you can send it to me, I'd like to include it in the next newsletter.
Very good, thank you. Anything else on this, guys? All right, let's move to the justice-related committees. The first one being Commons, Justice and Human Rights, and again, that's Howard.
Miles, thank you, Miles. Just trying to remember to turn off my mute. I'm going to be brief here. The Justice and Human Rights has met 5 times since our last PRC meeting. They had a meeting scheduled for November the 4th, which they canceled, and I'm not quite sure why. There are 2 topics that have been on their agenda over the last month. The first is their study of the government's obligation to victims of crime. On October the 20th, the committee gave drafting instructions to their analyst for a draft report. So until we see the report, I'm going to hold further comment on that. The other topic is kind of quite an interesting one, and I'm not quite sure how to deal with this. The second matter they've been consuming themselves with over the last month is their study on the, and I use this in quote unquote, subject matter of Bill C-28 on self-induced extreme intoxication. Now, they're not studying the bill itself because the bill was introduced in June and passed within days through both houses of parliament. The Bill C-28 was the government's, the Department of Justice response to the Supreme Court of Canada's decision in Brown, Sullivan, and Chan, where the SCC struck down section 33.1 of the criminal code as unconstitutional. 33.1 was the provision that said that extreme intoxication could not be used as a defense to sexual assaults and other crimes. I don't know where to, the decisions themselves we've talked about before. I put them in the newsletter, but they're very important material, and it's hard to comment in a few moments. The bill itself was a quick response by the government to the Supreme Court of Canada's rulings, but in my view, didn't do anything other than to restate what the law is. The Bill C-28 purports to enact or rather, let me put it this way, my apologies. The bill purports to strike down the defense of extreme intoxication where the extreme intoxication was as a result of the accused negligence. All right, but criminal negligence has always existed. Manslaughter, other similar offenses based on a negligent level of fault have existed for a long time, and nothing has changed. The SCC was really saying it in the particular case of its decision. The facts dealt with people who, for no understandable or foreseeable reason, became so incapacitated by drugs and alcohol that they were automatistic. They no longer control their actions or their thoughts. So that's not really what the Department of Justice is talking about. The review of the subject matter is very interesting, and the Minister of Justice appeared on October 24th. The transcript or the evidence of that hearing is available, but the two subsequent ones are not. So I haven't been able to get at that material without sitting and reading the tapes, and given my head cold, I haven't had the time or the patience to do that. So I'll report further on this. I'm not clear what the point of studying this bill is that's already passed and received royal assent, except that it was passed through both houses of parliament so quickly that there wasn't much time for debate. I'm waiting to see what the academic witnesses have to say who've been listed, who've given testimony, but I can't access their evidence yet. But my own view is that the government's bill is a bit of a sham. It doesn't do anything that wasn't already existing in the law, and the SEC decision didn't really say anything other than when circumstances occur that deprive an individual of the voluntariness of their action, then that's can be taken as a defense to a crime because there in fact is no voluntary actor. But those cases are so extreme. I think part of the problem is that the Department of Justice has been having to re-educate people on the law with respect to intoxication. So intoxication is not a defense to any criminal offense. Some with specific intent, maybe, but it's a complicated thing, and the division between general intent and specific intent is a legal theory that's difficult to grab a hold of for anyone. Anyway, I'm waiting to see what the conclusion of the standing committee is on the so-called study of a bill that's already been passed, but I need to kind of access some of the testimony to get a better sense of that. My own view, and again, it's just my own view, is the bill C-28 didn't do much of anything, but of course they're making a big deal out of it. I don't think anyone should feel worried or unprotected because of the SEC decisions, except in those extreme cases. in one case, the consumption was involuntary. In other cases, the mixing of substances was beyond the predictability of the individual who consumed the drugs. Anyway, they're extreme cases and very, very rare. It's odd that there were three of them sort of all bound in together. But I'm interested to see, I think this is, to the extent that these committee proceedings and the Department of Justice better explain the law to people out there about intoxication generally not being a defense, it's a good thing. But other than that, it seems to me to be more talk than walk, or more words than concrete action. So anyway, I'll stop my report there. But if people have questions, I'm happy to answer.
Thank you, Howard. Questions for everybody? Okay, let's move on to the next committee, which is Public Safety and National Security. And since Gil is no longer with us, Rob, you're the last man standing.
All right, thanks, Miles. Yeah, sorry to see Gil go, but yeah, he served us well. So this committee met 8 times since our last meeting. Mainly preoccupied with 2 things. One, Bill C-21, the firearms bill, and the other item they were looking into is the allegations of political interference in the Nova Scotia mass murder investigation. So as for Bill C-21, that's a bill that the PRC is following. If you, I noticed, I won't go through each of the meetings, but kind of try to highlight some things that were said and by who. So industry they're basically talking to different groups at this point, 6 meetings in total they have on that. So they're talking to the police, various jurisdictions. They've talked to firearms industry, women's groups, First Nations groups, and so on, a lot of different folks. Industry folks in the firearms industry tend to be concerned, especially those who are in the industry that supplies guns or sells guns or deals with anything to do with firearms that are replicas, like they're like the airsoft ones. They're caught up in this, or believe they will be caught up in this, and they have concerns about the definition of replica firearms. And if the definition of the replica firearms does not change, then this will affect what they do. And there's a lot of people in Canada who are, owners of such firearms and tend to enjoy using them. So you have a business kind of perspective, you have a regular citizen kind of perspective, and some of the things said there. The police tend to have some hope that in the long term, there could be or should be a reduction in the overall total number of guns in the country, again, in the long term. But they're quick to point out that the government should not forget that there are at the moment there's a great concern on the proliferation of privately made handguns made by 3D printers, parts being brought in from the United States, and these are being used in crimes. So there's a great concern there. There's also concern on the potential negative impact that the law could have, because as announcements have been made, there's, people have the heads up already that this is put on the table. So according to one of the police representatives, they've had or reporting that there's 20,000 new applications being processed recently, and for firearms, and 12,000 in the hopper waiting to be processed. So you have an increase actually in the purchasing and movement of guns as a result of all of this. There's some could talk about the red flag laws. There's concern, and this was one of the items we have in the under our list of 1, 2, 3, 4, 5, the 6 main points for the Bill C-21. They're listed on page toward the back of the agenda. The one regarding when people have to permit any person to apply for an emergency prohibition order or an emergency limitations on access order to allow the judge to protect the security of the person. So some concerns there about average citizens needing to go to court to seek such protection from a person who's, you know, causing problems now. So they felt that was, you know, there's some feelings there about this being somewhat misdirected, that, you know, citizens should be continue to be using the police for that as their first kind of line of defense when concerned about someone who has a firearm and perhaps and should not for whatever reason. There was concern about the over the long term. You could see gun ranges closing, memberships dwindling. Some gun ranges are actually used by police forces and others for their, you know, certifications or practicing and whatnot in different parts of the country. The Olympians were representatives. There's an Olympian, I shouldn't say the Olympians, an Olympian did test or provide evidence, you know, and competitive shooters as well. So, you know, having believing that there would be some effect on their ability to practice if gun ranges would not be available, or there'd be a lot of controls around the guns. So then the more recent meetings, they did not have the evidence available. They were talking to more police forces in those meetings. The 3 representatives from First Nations groups and some doctors and others. So that was in a nutshell what happened. It seems like there's a mixed feelings about this clearly, and if anybody has any questions or would like me to delve into it further and report back, I'm willing to do so. Thank you very much.
Thanks, Rob. That was very comprehensive. Anybody have any questions for Rob? Okay, moving on up to the Senate now. So the Legal and Constitutional Affairs Committee, that's Brendan.
Hi, everyone. The Legal and Constitutional Affairs, they have met 5 times since our last meeting. They are discussing 3 bills. 3 meetings were on C5, which, as you all know, is a bill that the PRC worked on. They also were discussing bills S205 and S210. Both of them are private members' bills. I'll go through those really quickly before I attend to C5, because C5 is a little more to say. So, like I said, S205 and S210, they both received one meeting. S205, if you recall, this was a bill that we looked at previously. It was introduced in the Senate in 2021 by Senator Miguel Deschênes. It's about youth access to sexually explicit materials online and how to institute age verification technologies. So they went through a clause by clause review of the bill. As was reported in previous meetings in the spring, there's concerns about the privacy of people providing the information to verify their age. There's also general consensus among the senators that, of course, this bill, even if it is put into law, that it certainly will not stop young people from being able to access sexually explicit materials. But the bill did pass in the Senate. I wasn't able to see the final output once the consideration, the clause by clause consideration was done, because this meeting was only last week, I believe, so I haven't been able to see the final product. But I believe it will be going out of committee back to the Senate next. Bill S10. This is a new bill, and actually this is one that I was thinking when Howard was mentioning how his students had interest in intimate partner violence and whatnot. This is, again, a bill introduced in 2021. It's Senator Pierre Boisvenu. It's essentially about modifying Section 810 of the Criminal Code in terms of peace bonds and whatnot, unless I've misread it, but that's my impression of it. It's to add specific conditions in cases of intimate partner violence. One of the big things I saw was that it seems like the senator wants to introduce the possibility for the new form of an 810 order to last 3 years, and if an individual does not, if the person, typically offender, for lack of a better word. I know that's not the right term in this situation, but the alleged aggressor could be subject to 2 years of imprisonment if they decide not to enter into a recognizance. So the bill this meeting just looked at presenting that bill. As for C5, there was a few meetings with various stakeholders, including academics, including Cheryl Webster and Julian Roberts. The Honorable Murray Sinclair presented, as well as members of the Canadian Association of Chiefs of Police, and some women's groups, specifically ones that deal with Indigenous women. Again, more or less the same that we've been seeing in terms of the submissions, that most people are favorable to the bill. They don't think it goes far enough. Many people are saying that all mandatory minimums should be completely struck from the criminal code, and if not, we should at least implement a safety valve provision in the criminal code. Of course, there are some women's groups are not in favor of that, particularly because they're afraid of, I shouldn't say afraid, they're concerned with sexual offenders being able to serve their sentence in the community. That seems to be where a lot of the resistance is coming from. With that said, the committee went through a clause by clause consideration of the bill. Senator Pate actually proposed instituting the safety valve provision in the criminal code. Unfortunately, this did not pass. That change was not implemented. There were fears among several senators and as well some witnesses that this would not pass in the House of Commons if such a provision was in the bill, and they would rather have an imperfect bill pass rather than trying to implement that immediately. Some senators were also concerned with the fact that they were trying to implement that safety valve essentially as it was heading back into the Senate. They were worried that it wasn't well thought out enough. And finally, some senators did mention that Bill S-213, I believe, is sort of a similar attempt to institute a safety valve. I know we're just about done, and I would just say that one senator also did attempt to add restrictions in the use of conditional sentence that were not originally in the bill, essentially disallowing CSOs for sexual offenses and among others. That did not pass either, and that's where we are for that committee. Sorry, hope I wasn't too long.
No, that was great. No, thank you, Brendan. Any questions or comments for Brendan? Okay, we'll move on to the committee I'm looking at, which is the Senate Committee on Human Rights. It met twice since our last meeting on October 24th and October 31st. The committee isn't working on any work on a bill. The last bill it dealt with was Bill S-224, which dealt with trafficking in persons, and that was over 6 months ago. What it's studying ostensibly is the discriminatory nature of Islamophobia in Canada. So it's calling witnesses to give their there's some academics, a lot of people who just want to give their personal stories that relate to that particular topic. So they're just what they're going to do on assessing the evidence, and I presume prepare a report when the committee meeting ceases taking place. Any questions on that? Again, this committee isn't very active. It hasn't been since I've been looking at it, but that's what it's doing these days. Okay, so let's move on then. So we'll go further down the items. Item 5. There's again, I'm not going to go through the waiting briefs. We're now at 1 o'clock. We've lost Matthew, I don't want to take too long. But having said that, item E, the invitation letter for consultation on facial recognition. Peter and Lynn are still preparing a final draft for review. Is that still underway, Peter?
Yeah, it's still underway. I've got to get back in touch with Lynn. We've been out of communication for a couple of times.
Okay, thank you. Item H, alternatives to incarceration. This is now a relatively long-standing issue. Matthew has indicated that he was going to prepare a draft letter for submission to the Minister of Public Safety, which is essentially I believe it's the historical positions of the CCGA over time on this issue. But Matthew's now left us, so we can't ask about what's happening there. I will bring that up next time. Item H, proposed discussion. I brought this forward last meeting regarding seeking provincial support for a uniform approach to record suspensions and how they're dealt with basically at all human rights committees across the country. Howard very helpfully suggested that what I should be looking at is the engagement of the Uniform Law Conference of Canada, and I did look that up. And as it turns out, that particular body, in fact, produced a report in 2018 on uniform police record checks and how to approach them. So, which is obviously very much very germane to what I'm talking about. That particular report that was generated and adopted dealt with a working group trying to get all the provinces and territories to come up with the same approach to how record checks were used by the police when applications came to them to reveal whatever data they had to reveal. And what the group came up with is that they thought that what Ontario had done with the Police Record Checks Reform Act in 2015 was the way to go. And so their recommendation was, in fact, for everyone to adopt that particular approach. And what that approach was to standardize the types of criminal record checks to be provided, to limit the disclosure of non-conviction information, including the development of disclosure criteria, and then to provide for appeal and reconsideration processes to correct inaccurate information and to challenge the inclusion of irrelevant information disclosed in criminal record checks. So that was adopted. And obviously the point of all that is that, you know, record checks should be used for a very clear purpose, the purpose being known. Extraneous information shouldn't be contained in them, because obviously if an employer gets a record check and it sees information there that doesn't necessarily relate to a record, a criminal record, then that could prejudice an application for employment and what have you. So at this stage of the game, so my teaching schedule was kind of crazy the last month, so I haven't done a lot more on it than this. I still need to assess, you know, on a province by province basis exactly what the position is with respect to how, you know, how their human rights codes approach the issue of a criminal conviction as a item or as a ground of discrimination and how it's treated, and to see if and obviously come back to the PRC and then the CCGA, come back to see if there's some common ground we can come up with that we think would be an appropriate approach to take to the uniform group for presentations. So I don't have much more than that for this today. Any questions about that? Okay. All right, guys, thank you. Okay, moving on. What we have now is we'll move to bills under consideration. All right, and there hasn't been a lot of activity on this since our last meeting. A few things. Do Howard and Brendan want to say anything further regarding C5? No?
I might just add very quick. Sorry, Howard, you can go if you'd like. I was simply going to say, I think based on what we presented as a PRC, I think a lot of that was reflected in the testimony of witnesses that were there. I think there was quite a bit of consensus among witnesses. So I think the CCJA was in good company in what we proposed.
Very good. Thank you. Okay, the only other government bill that's on our agenda is Bill C9. It's a bill to amend the Judges Act to essentially put into place a review mechanism regarding misconduct. It had its first reading December of 2021. It actually had its second reading in October 31st. So that's where that is. So that's the only other activity for government bills. For private member bills in the Commons, the only activity that is different than last month is Bill C283, which is a bill that deals with addiction treatment in penitentiaries. And it just moved for its second reading, which is in progress. And then we have a new private members bill, Bill C303, which is, interestingly, it's a bill to basically require that all directions from the Commissioner of the Role, the RCMP, to its membership be in writing and reported. And I have to think that's the Brenda Lucky and Bill Blair. What came out in the hearings with respect to her ostensible or not conversation with Blair as to get the nature of the weapons that were being used in the maritime issue back to the government. Anybody have any questions or comments about that? Again, it's a private member's bill. We'll see what happens with it, but it's
What was the bill?
November. Peter?
What was the bill number again, please?
Bill C-303.
Sorry.
First reading November the 1st.
Okay. I won't see that in here. Oops, sorry for being so long here.
And what it actually says is that it's
Oh, okay, yeah, no, I got it now. Sorry.
and I'll just read it out. It's just to clarify the scope of the directions that the Minister of Public Safety and Emergency Preparedness can issue to the Commissioner of the RCMP and to require that all directions be issued in writing.
Yeah, I just want to quickly comment that I think, especially in light with what Rob McGregor was saying before, and the allegations of the political interference, I think that's actually a very important bill. It's not going to actually do anything because I can't see any of them doing anything in writing, because then you'd be held accountable, which would be a shame in itself. But I do think that is a very important bill and worthy of us watching, just to see what plays out of it, and especially if it gets into any discussion at committee discussions or stuff like that.
Well, absolutely. And then so it's on our agenda. We'll keep track of it and report back next month. All right. In the Senate, we have no government bills to discuss. With regard to private bills, Bill S-224. Again, this is actually was the bill that was dealt with by the Human Rights Committee. Trafficking in persons. It's had its third reading in the Senate on October 26th. And first reading in the Commons October 18th. So it's going that route. And lastly, on our private member bills, we have Bill S-255, an act to amend the criminal code which basically amends the code to classify the murder of an intimate partner, one's own child, or intimate partner's child as first-degree murder. That's the premise of that bill, and it had its first reading on November the 2nd. And that's it for the bills. Anybody have anything else they want to bring to the attention of the PRC for the good of the membership? Howard, take care. Feel better?
Thank you. Thank you.
Right, guys, thank you very much. Appreciate it very much. We'll be back here on, I believe it's December the 13th.
Yep.
Okay, very good. Thank you, everybody.
Take
Take care.
care.
Everyone.
Right.
Bye-bye, thank you.